Kia ora everybody, good morning. We've just got a few matters that we're just needing to share with you before we get into the submissions of Ngati Kahunu Incorporated. We've had one request from the Hawke's Bay Regional Council just to share with you an issue with the Section 42A addendum report. We'll deal with that soon. But there's a few procedural matters I just wanted to cover firstly with your indulgence. The first one of those is in the legal submissions for Ngati Kahunu Incorporated. There was two matters raised, and one of those I'd like to deal with that first this morning, and that's regards matters that were raised yesterday in evidence and also in verbal submissions, and also with through the legal submissions of the time frame for submitters to respond to in particular the Section 42A addendum report, which submitters would have received just a few days before the hearing, including ourselves. And so the issue that's been raised with us is in regards to the short time to respond and the fairness, because those who are in week 2, which is in a couple of weeks from when that was received, and those who are in week 3, which is a few more weeks, they've had more time to respond, to be able to read, have their own discussions, and then respond to those in a meaningful way in the hearings. And that same amount of time hasn't been afforded to those submitters in week 1. So we've had a discussion about that yesterday, and we're quite open to the idea of trying to find a way in which some specific comments in regards to the addendum report related to their submissions, etc., you know where I'm going with this, in terms of having some tight bounds around responding to that particular report. We're of the view that we'd like to issue a minute in that regard. I just wanted to just share that with you, just to see if there was any particular comments in the first instance.
Morena, thank you, Mr. Chairman, for raising that, and as you rightly say, it was addressed in our written submission. We've suggested one way forward, which is to borrow from our time slot today, because our ambition is to finish by lunchtime if we can, to ensure we're focused in terms of our presentation, and to ask for up to an hour in week 3 for the iwi authority to provide an additional response. You'll note, for example, that Ms. Wilson has provided you with track changes to the original version of the 42A report, but has not had that opportunity to do an amended version that responds to the latest addendum. And of course that would assist the commissioners to have the correct version in front of you. And there is, as you have helpfully pointed out, that week 1 we only get the 2 working days, whereas others have more time. So we're grateful that you've indicated a willingness to be flexible. So a bit of additional time in week 3 is our suggestion. With perhaps, it also depends if you're going to direct caucusing as between planners before week 2 or week 3, and of course that could be an efficient way of moving things along as well.
Yeah, just in regards to point 2, I was going to pick that up later on when you do your submissions, but we've said in our previous minute that we're open to the idea of caucusing, so that's noted. Just in terms of what the form of that, perhaps might hear from the council as well, if you had a view on this.
Yes, we're happy to take direction from you. I think it would be helpful if the submitters from this week were given a little bit more time to read the addendum report.
So just putting a hypothetical situation out there, if we were of a view to seek written comments in regards to the Section 42A report related to your submissions with some tight bounds around that, and we were to receive that 5 working days before that time slot for the hearing, would that be something that you'd be open to? Yeah, that's right. So we're just dealing with the people who are in front of us and those who've requested, and there was evidence from Te Tai Whenua Heretonga yesterday that actually raised that issue. So that is the issue that we're discussing. Yes.
The proposition, and I'm sorry if I wasn't clear, certainly all tangata whenua submitters would benefit, and the iwi authority would support that, absolutely. It would naturally be of help, of assistance, and this might be something that can be done at officer and expert level, to have some sort of actual response from council officers to the substance of the track changes put forward by the iwi authority on behalf of the tangata whenua submitters. So, but anyway, that the 5 working days prior sounds reasonable.
Okay. And you'll appreciate a request for an hour of time in week 3 may be accommodated, but there are other submitters as well. So I beg your indulgence in terms of how we might be able to. I think there's a view that we'd like to accommodate, but it just needs to be done in an efficient and effective manner.
Thank you. I'm grateful, Chair, for that.
Okay, thank you. The next matter is just, yeah.
We'd like to, I think the Kahunu approach is really important. So I'm not sure quite if it's just by written submission.
Oh, sorry, you may have misunderstood what I said. It's 2 things. One is that we're looking to get written comments 5 days before the appearance and the hearing of week 3, and providing some time, but just noting that we've already got a timetable, and we're best efforts to make sure that everyone has their say and can talk to those submissions. Okay. The next matter is just in regards to, and appreciate all the efforts of all parties in regards to preparing for this hearing and the tight timeframes, and we provided some extensions to the presentation of expert evidence, and we were open to accept lay evidence so we could have a read of it before the hearing. And I just wanted to see if you had any view in regards to how we might deal, because some of the evidence that's provided after the extension date some of it looks like expert evidence. We've received it and read it, and just whether you had any view about how we might approach that.
So that's the second procedural matter raised in the written submissions. Basically, it really relates to Shade Smith's evidence, and I understand that at least some of the commissioners here are familiar with his background and his expertise, his acknowledged expertise. So we would certainly prefer that his evidence was treated as expert evidence in the sense envisaged by the expert code of conduct, and he can today confirm he did prepare his evidence in compliance with the code. That would then allow him to be involved in any caucusing that you may direct. The other point in it, this relates to Ngaio's evidence, is that essentially it is only tangata whenua and mana whenua who are experts in their own tikanga, and so the compliance with the code of conduct is a bit of a side issue in relation to his evidence. So the issue really, the rubber hits the road in relation to Mr. Shade Smith's evidence.
Okay. Yeah, what we'll do is we'll hear Mr. Smith, and we'll make a determination a little bit later on.
Thank you.
Okay. But in regards to the request for Mr. Smith to be part of caucusing, if that occurs, that's noted.
Thank you. That's
Thank
great.
you. Now we'll just pass over to the council. I understand that there was a matter in regards to the Section 42A addendum report you wanted to raise.
Yes. I may have been somewhat hasty in summarising some of the expert evidence and misrepresented the evidence of Ms Wilson in relation to freshwater farm plans. It doesn't change my recommendation. I inadvertently suggested that Ms Wilson didn't support freshwater farm plans, but that clearly isn't the case. The second item was in relation to a consequential amendment to the RRMP, the Regional Resource Management Plan, which had an objective for protecting the aquifer water quality for the Heretaunga Plains, and was previously also referring to the Ruataniwha aquifer. By deleting reference to the Hiratonga Plains, we inadvertently made the objective refer to the rest of the aquifers across the region, which wasn't the intention of the objective in the first place, and certainly wasn't the objective in the plan change process. And Ms Wilson's evidence highlighted that problem, so we consequently deleted that whole policy rather than leaving it referring to the entire region by mistake.
Okay.
So hopefully that's...
Perhaps that might be something you can pick up in response. In terms of a note, that includes those matters. Thank you. Any other questions? Yes,
Sorry,
Mr.
just
Blake.
on,
Oh, sorry.
sorry, just on that, I think Ms Wilson can probably give a more fulsome explanation, because Council's addendum report relies on relief sought by the iwi authority basically 180 degrees away from what we were asking for. So there is a problem in the recommended changes put forward, and we'll just, Ms Wilson can answer that when she...
We'll cover those when we get there. Okay. Mr. Black? Okay. Very good. Okay. In terms of today, Ngati Kahunu iwi Incorporated, and as Leonard Fred has indicated, up until around lunchtime, we have Environmental Defence Society this afternoon. As I understand, this was the only day that they could attend the hearings. Have we got, it's Cordelia Woodhouse?
No, I'm appearing also for EDS, so...
Yes. Very good, you're here. And Mr. Owen Jerry Hapuku, who had joined us yesterday afternoon, and he's going to be our last speaker this afternoon. Yep, let's talk about. So we're looking at finishing, and then we're going to have a afternoon tea in Poroporoaki. Just in terms of timeframes for the panel to get away, we've got to catch at least 2 flights this afternoon. We're needing to be leaving by 4:15 this afternoon to catch our flights. It looks like our timetable will meet that, but that's just...
So just for clarity, the lion's share of time is for the iwi authority, and we're endeavouring to chunk it down to finish before lunchtime if we can, but subject to questions, of course, so that we retain your interest. Thank you.
Okay. I thank you for that. What we might do, Mr. Enright, is if you're able to just give us the batting order of the... We've received the list of those who are going to appear, but if you could just go through maybe perhaps introductions and just a quick brief again, who's going to be presenting what.
Certainly. So we were hoping to commence with Ngahi Tomoana, who's the chairperson of the iwi authority. However, he apologises, he has a hui in Napier, so he'll be second in the batting order. I'm going to go first with the legal submissions, followed by essentially the order at para 40 of my submissions. Naio Tiuka will go next, followed by, I think Peter was going to go, sorry, then Shade, followed by Peter Fraser to the right, who's the expert economics, and of course our planner, Gray Wilson, to my left, will conclude.
Right, thank you.
And we were hoping to spend a bit of time, and I'll cover it briefly at least in my legal submissions, on our actual proposed relief, because we're endeavouring to assist commissioners, and of course at the end of the day this is an exercise in, you know, what are the changes required to make the plan change appropriate and fit the statutory imperatives. And we've really put forward 2 pathways for you as commissioners. One is radical changes need to be made to Plan Change 9 so that it gives effect to the higher order statutory imperatives, the Te Mana o Te Wai National Policy Statement, Freshwater Management, the directive policies in the Regional Policy Statement, Section 6E RMA, to recognise the relationships of tangata whenua with their taonga and their ancestral waters. So that's pathway 1, radical change. Pathway 2 is decline. Recognise that the collaborative exercise Council has been undertaking for 10 to 12 years has essentially failed, and that is why you have tangata whenua submitters almost universally opposing most of the plan change provisions. So there are really those 2 pathways. But we are endeavouring to be constructive, and of course Ms Wilson's duty to commissioners as an independent expert is to assist you. So that's why we've put forward in substantial detail an alternative version of the plan provisions.
Just in terms of that relief sought, and excuse me, we've read quite a lot, so my understanding is that the relief sought was, yes, those two, or the council withdraw the plan change, is that right?
Yes, but withdraw decline.
Okay.
So I think your power is to decline, but given you've got full delegated authority, as I understand.
Yes, that's right. Okay, thank you.
Thank you. So, tēnā katoa ko Rob Enright taku ingoa. As you've heard, I'm counsel for the iwi Authority, and I'll just step through rather than read the legal submissions provided to you. So the iwi Authority is the mandated iwi Authority on behalf of affected tangata whenua. The iwi Authority supports the hapu and marae that exercise mana whenua and rangatiratanga over the areas identified as the tank catchment. And just recognising that the exercise of rangatiratanga and kaitiakitanga is a duty and a responsibility to the water and the ancestral taonga, as you've heard in the evidence over the last 3 days. And so the important starting point for the iwi Authority is the whakapapa that exists between hapu, iwi and their waters, and you'll hear more from that from Ngahiwi when he gives his evidence. He will also cover the importance of the aquifer in terms of that connection between what is underground and what is above ground, surface water and groundwater. So understanding whakapapa is key to understanding the cultural values to be recognised and provided for as an integral part of the plan change. Whakapapa creates a connection to both the physical and spiritual worlds, as we've explained. So as we say in para 4, we are putting forward 2 alternative pathways to you, one being substantial amendment, the other being a decline. And, you know, recognising head on that the timing of this plan change, you might say, is somewhat awkward in the sense that it's been passed by the, obviously it started off in an environment of NPS 2014, moving to 2017. Now, of course, we have the NPS 2020, which became operative on 3 September of last year. While that may be the case, you know, RMA is a dynamic practice, and this kind of thing happens a lot where you have overlapping planning instruments. So the Regional Council is familiar with that. It's not an unusual or particularly novel situation. You should also bear in mind that the 2020 NPS came in at a relatively early stage in the statutory process. So, for example, some of the submitters, including the iwi Authority, actually refer to the 2020 version of the NPS. Everyone had it within contemplation when they prepared their submission. So it's not an ambush, it's not really taking submitters by surprise that you now have to deal with the more directive provisions of the 2020 version of the NPS. And that's material in terms of how you give effect to that instrument, particularly in relation to the hierarchy, te mana o te wai. So I've set out for you just kind of a summary of issues and the key witnesses you'll hear from today in para 6. And it is, as a starting point, Ngati Kahunu goes back to 1840 and the exercise of full, exclusive and undisturbed rangatiratanga, possession and control of the tank catchments. There has been no extinction of that right. Ngati Kahunu continues to exercise rangatiratanga and kaitiakitanga over the tank catchments, which are, as you know, over-allocated, with mauri and water quality both being substantially degraded. The iwi Authority relies on the values and principles that are set out in the iwi and hapu management plans, settlement legislation and the statutory acknowledgements, which collectively acknowledge Ngati Kahunu's role as a treaty partner. Just on the statutory acknowledgements, those are covered in Ngaio's evidence, and he may touch on them today, but he certainly deals with them in his extensive written evidence because they are a relevant consideration for you under Section 6 RMA, separate to Section 6E. NIO also refers to the relevant freshwater reports from the Waitangi Tribunal and gives you some of that context. In terms of the statutory framework, you have had a helpful, succinct summary of that from the council lawyer on day one, but I did just want to remind you of the statutory functions, para 11, which refers to section 31C of the RMA, and the requirement to maintain and enhance both quality and maintain quantity of water in water bodies and coastal waters. So this idea of collaboration, we found very helpful. The question posed by the chair on day one around, well, what would you have done it differently if you could turn the clock back? And it seems that the answer was a sort of qualified yes. Certainly from the iwi authority perspective, the collaborative process has failed, and the consequence of which is you have quite diametrically opposed positions now in terms of the submissions. And I've sort of referred to them as, in some ways, these are competing paradigms. What's important for you as commissioners, though, in my submission is that you can rely on the National Statement of Priorities as your guide as to which way you should swing, because, again, that is your legal duty, and that is the Council's legal duty in terms of Plan Change 9 to give effect to that statement of values at national level, the NPS, and at regional level, obviously, the RPS. So whilst there are these competing paradigms, we submit the answers must follow from how you give effect to the NPS and RPS. My para 13, I do make the point, but I won't labour it, that the 42A assessment by the Council quite often offers up as a reason, substantive reason, why you should reject submission points, including from the iwi authority, that, well, the process was collaborative, therefore that's a reason not to accept relief proposed, and we say that's a bit of a cop-out with respect, a bad answer. It doesn't really engage with the merits of submitted positions. The mere fact that there has been collaboration does not of itself give a decent resource management answer to many of those issues.
Just as a matter of discussion, one of the questions I'd asked of Council following the question about would you do it differently was that in the Section 42A report and the Section 42A addendum report, there are a number of instances where the council staff have rejected the relief sought by a submitter, in particular the iwi submitters, due to the reasons that engagement, including consultation, hasn't occurred under the auspices of the National Policy Statement 2020. And my question was in regards to the engagement that had happened over more than 6 years. Do you disregard all of that engagement and then start again? And then the engagement for the MPS-FM 2020 is relevant, but hasn't been done yet. What's the balance between? And it just goes to the core of your comments in regards to the collaborative process has failed, but engagement has happened, and which has covered many of the issues that might be relevant to the implementation of the MPS-FM 2020.
It's an illuminating question because why would you disregard the engagement? It's clearly on point in relation to the same values and relationships, the same water bodies that will be dealt with now and will be dealt with by 2024, specific to the tank catchments, obviously. So you can't disregard the history of engagement, which has been going on for many more years, as I think some of the submitters have said, than simply tank. And I think it's more time for tangata whenua want to be heard, rather than in the endless talk fest. So I will bring up the NPS 2020 shortly, but yes. Clause 3.7 refers to, for the NOF process, at each step of the NOF process, Council must engage with communities in tangata whenua. And so we would say, well, you've had an awful lot of engagement. Unfortunately, it hasn't got to a place of consensus, but it's time to actually implement some hard lines, some environmental bottom lines, essentially.
Thank you.
And so that's a point made in 14 and 15, is that you do have quite stark positions in some ways of, understandably, commercial users are keen to protect their existing allocations undisturbed, what we've called a bit of a status quo position, but on the other hand, the position of the tangata whenua submitters and the iwi authority is that it's now time to implement a values-based approach that puts nature and water first, which is because, again, that's where Parliament has directed we should go through the NPSFM, or the government has, I should say. Even if that will disturb over time existing allocations of water to commercial users, because we are in an over-allocated, over-abstracted context. And you've heard, and I think you can certainly draw the conclusion from the evidence you've heard over the last 2 days, that there are significant adverse cultural effects arising from the over-allocation situation we have here, where you cannot engage in basic cultural practices, as you've heard, both physical and spiritual practices. And so we are in a bit of a crisis point because of those practices simply aren't happening. And one, I think, quite a powerful point that Ngaio makes in his evidence, and we'll put the map up if the technology allows it, is to just have a spatial review of the proximity of marae to their water sources. And obviously each marae traditionally has been located beside a water source for obvious reasons, and a number of those are now dry or they're unavailable. The puna, the springs are not there. So there is that immediate ongoing effect on the relationship of marae with their waterways, their ancestral waterways. As I say in last sentence, para 15, while there are competing paradigms, the national framework and statement of priorities is clear. I've then gone into Part 2 RMA, and as a matter of sort of RMA practice, quite often now we see planners scooting around to some extent Part 2 because of what happened post King Salmon and the Davidson decision around, well, do you actually need to go there or not? But I submit you do need to go there because you have a unresolved planning framework. Simply put, Plan Change 9 itself, you need to have some regard to Section 6 in particular in relation to standards imposed in Plan Change 9. So I've picked on in particular Section 6E just to remind you of the duty to recognise and provide for the relationship of Māori with their ancestral waters and taonga. I do of course acknowledge that there are other sections in Part 2 RMA. It's not simply a case of Section 6E, and as you know, sustainable management is a wider umbrella. So moving into the key issue of the NPSFM 2020, and I was hoping to put that up on the screen just briefly if the hearings person can put it up for me. The National Policy Statement, Freshwater Management. It was one of my appendices to. Thank you. So I appreciate that commissioners will be very familiar with this instrument, so I won't overdo it. But just turning to clause 1.3, the fundamental concept, te mana o te wai, that's on. Yeah, that's it, thank you. Of interest in para 1, last sentence, it refers to restoring and preserving the balance between the water, environment and community. And, part of restoring that balance might be to re-look at the way in which we approach allocations and the maximum quantity of those allocations. If we're going to restore the balance in favour of nature first, there do actually have to be consequences arising from that in terms of some hardline policies and rules. If you scroll down to sub 4 on that same page, you're familiar with the 6 principles of te mana o te wai, but they do include in B kaitiakitanga, and it's couched in the language of duty and obligation, so the obligation to preserve, restore, enhance, sustainably use. So that sense of duty was very evident and prominent in the evidence you've heard, and a lot of the emotional evidence, appropriately emotional evidence around the failure to exercise katiakitanga because of the lack of water availability. Water poverty, I think, has been described in that way. And then a very clear statement, scrolling down to bracket 5, thank you, of the hierarchy of obligations. There can be no doubt as to what comes first. It's not health needs of people, it's not social, economic, cultural well-being, it is the health and well-being of water bodies and freshwater ecosystems. So that is your first priority.
So how do we reconcile that with Section 5 of the Act, which is its purpose, which says effectively that it's meeting the needs of people while at the same time meeting what have been called environmental bottom lines? This recasts that in terms of giving priority to the environment. I would have thought that the purpose of the Act would override this hierarchy in terms of our decision making.
So that's an important question. I'm grateful for it. So as we discussed before, I agree that one should have regard to Part 2, and that includes Section 5, obviously. But you have got, the Crown has spoken. They've had regard to sustainable management, and they've given you the script. They've told you where to put your priority. And so sustainable management cannot override what is so clearly stated in subsection 5, bearing in mind the mandatory duty to give effect to the NPSFM. So there isn't any ability, there's basically no choice left to you but to follow that priority statement in my submission.
Is there any case law that would support that particular view?
Yes. So I've reminded you of section 67 bracket 3 RMA, which you'll be familiar with, which is the language of give effect to. The best example is actually King Salmon, because in that case, similarly, it was a plan change to a regional coastal plan, and the Supreme Court made a decision that, as you know, the plan change did not give effect to two policies in the coastal policy statement, policies 13 and 15, and so the Supreme Court declined that plan change, giving effect to policies 13 and 15 of the CPS. So that's the precedent example I would rely on.
Thank you.
And so again, it's a very helpful question because it does bring into stark relief what is the priority statement. It's been given to you, and you should give effect to it as you must, as your legal duty in my submission. Just a couple of other provisions I wanted to bring to your attention. If you could please go to 2.2 of the same document, policies. And can you just expand it a bit, because it's a bit hard to read? That's better, thank you. So, harking back to King Salmon, as you know, essentially the language used in each individual policy gives you a clue as to whether it's directive or permissive or discretionary. And so when one goes through these policies, there are a couple that stand out that are directive, and so they go up in the hierarchy as between other policies. One being the first policy, obviously managed in a way that gives effect to Te Mana o Te Wai. As you know, the language of give effect to is the strongest in the hierarchy rather than consider or be consistent with. It is at the top of that sort of language hierarchy, and of course policy 11, importantly here for plan change 9, directive language, freshwater allocated and used efficiency. Then the keywords here, all existing over allocation is phased out, future over allocation is avoided. So our focus in terms of Gray-Wilson's recommended changes very much zeroes in on the need to phase out existing over allocation so that we can return to a nature and water first prioritisation approach. And then if we go to 3.2, please. And this, I think, harks back to the Chair's question around how do we deal with 12 years of past engagement? Because as you see in bracket 1, every regional council must engage with communities and tangata whenua to determine how Te Mana o Te Wai applies. And so that history of engagement is relevant here, but not binding in the way in which you know, what substantive outcomes you determine apply, in other words, the planning provisions.
Did you have a view in regards, because Te Mana o Te Wai obviously was in the 2014, updated in 2017, you know, as a matter of national significance, and then the change to must give effect to, do you see them being quite different concepts in the change of the weight that's been given and the articulation in the new MPS?
Yes, it's a good question because, again, in terms of that language, it is hierarchical and must give effect is certainly higher than a previous consider or be not being consistent with, etc. So it is a stronger duty. And I think, again, that's another good answer to the Commissioner Cowie's earlier question about how do we balance that out with, you know, Section 5. Well, actually, there's no balancing here. One has to implement the directive language. I think that's probably all for now on that. Thank you. And in many ways, we've covered off what I had to say in my written version at para 22 and following about the legal duty as submitted. You will have seen when I next give submissions for EDS, we've gone into some more detail around the case law that applies, so I don't need to deal with that now. I'll come back to it subsequently. But, you know, just again, dealing head on with this issue of what happened from 3 September 2020. Well, the 2020 version became operative. There's no transitional regime. It's quite unusual in some ways. I mean, often you have an ability to consider two in parallel. But instead you've got a bright line here. And, you know, rightly or wrongly, that's the approach the Crown has adopted. So, you know,
Approach and regulations leaves a bit to be desired.
I'm sorry?
Your approach in some of the regulations leaves a bit to be desired.
Yes, right. Well, there you go. But that's the call made by, isn't it, by the Minister for the Environment. So we've got to follow suit. There is a point, though, about my para 24, the main issue being the how in terms of detailed drafting and being within scope. But I think an important point that Liz made yesterday for Heretaunga Settlement Trust was that it's not just an abstract concept. Te Mana o Te Wai has practical consequences, and we're talking here about the relationships of tangata whenua with their waters, with their ancestral waters. In para 25...
Oh, sorry, just before you go, just at 23, you just noted the last sentence in that paragraph, Council for Regional Council has identified the relevant scope principles, and I just had a question whether you agreed with those principles.
On the whole, I think it's the way in which you implement them that can be tricky. But, you know, the idea that a submission must be on the plan change to have scope, agree with that. How one applies that can often be difficult. A point that I think the EDS submissions make more clearly is there is this extant duty to give effect to the 2020 NPS, and so scope to do so is engendered by whatever was in the notified version of the plan change plus the relief sought in submissions. The submissions give quite wide-ranging scope, and I think that's a problem with the Mitchell-Dace report. It's a very useful report because it gives you a red, yellow, green, which is actually quite helpful. But there should be another column in that report saying, well, what scope is also conferred on you by reference to submissions in terms of giving effect to the MPSFM, quite wide-ranging, particularly, for example, if you were to rely on scope conferred by the iwi authority submissions. So in some ways we need another column in that report for it to be even more helpful.
Thank you.
And as we say, if you were to add the next column, there would be a lot more red light areas where plan change 9 isn't going far enough to give effect. So moving to the RPS, and again, as you're aware, because this is a plan change at the regional plan level, we also have to give effect to the RPS. And did just want to remind you of two. There are a number of policies, admittedly, that are relevant, but they do include directive policies, and at para 26, I've reminded you of policy objective LW12, maintenance of overall quality and improvement of water quality in water bodies that have been degraded to the point they are over allocated, and establishing where over allocation exists, avoiding any further over allocation, and phasing out existing over allocations. So it's again a very directive language there around it's time to get on with the job of reducing the over allocation problem we have here, again, so that we can restore those natural flows under Te Mana o Te Wai hierarchy. Naio, in his evidence, reminded commissioners of the Plan Change 5 decision, Ngati Kahunu, Hawke's Bay, and I think one of the reasons he refers to it is that he appeared in it and was successful on behalf of iwi, so it was a notch in his belt. But it's quite a good decision just to revisit, and that's why I've given you a copy, just because it reminds, it is just addressing this issue of, unders and overs. We have to actually apply that in relation to each water body, not on a kind of, you can't just average them out over the whole region. And the importance of Objective 42 and the RPS Objective 21 around no degradation of existing groundwater quality in the Heretaunga Plains aquifer systems. So it's a very strong bottom line. I think it's a point made by Ms. Wilson, her evidence, that you still have RPS Objective 21, which more or less says the same as the quoted Objective 42. And this plan change must give effect to RPS Objective 21. So there would, if you remove the directive wording, there will be a gap. You won't be giving effect to the RPS Objective 21. That's why she's recommended it come back in, and I'll explain that point when we go to her wording. And that perhaps might be a good point in time to do that. Now, if we could please bring up the track change version attachment to Gray-Wilson evidence. So you're going to have to go to the appendices. After page 29.
No, keep going. Keep
Yep.
going.
Okay, and just stop there for a minute. If you could please go first to, has this got page numbers on it?
No, sorry. My
Unfortunately, it doesn't
apologies,
have
there's no page numbers on there.
the page after the intersecting circles diagram. Yeah, next page. Yeah, that's it. Yeah, so that's two more pages down, sorry. Objective Tank 3A. Next one, next page. Yeah, and just if you could expand it slightly just to make it a bit easier to read. Yeah, that's good. Explanation as to why Ms. Wilson has recommended reinstating Objective Tank 3A, no degradation, is that that is required to give effect to RPS Objective 21. So you actually need that in there to give effect to the RPS. That's the simple explanation. So if we just go back up one or two pages to Objective Tank 2. Yeah. So what Ms. Wilson's recommended is a fairly clear statement at the start about what are our priorities in a way that mirrors the NPSFM 2020. So our priorities are to sustainably manage in a way that gives effect to Te Mana o Te Wai and Ki Tai. So that is an explanation or context to that recommended change. objectives 2A and 2B are hopefully self-explanatory, but just to reinforce the significant values in 2A and in 2B, restore, revitalise the Māori and Te Mana o Te Wai of all waters within the catchments, and recognise and provide for Ngati Kahunu's relationships. So none of that should be controversial, but we say it needs a forefront statement up front about what are the key outcomes envisaged. Sorry, scroll down to 2A, 2B, yeah, and then 2B, just next page. Yeah, thank you. If you keep going to tank 16A, objective tank 16A, it's about 3 or 4 pages down. Yep, that's it. So by 2035, restoration of at least 70% of the natural flow within the surface waters of the tank catchments, and to maintain existing groundwater quantity. So those are, again, relatively directive objectives we say are appropriate, or Ms. Wilson, I should say, says they are appropriate in light of the significant adverse effects, the evidence of which you've heard in the last few days. And perhaps if you could go down to policy tank 35A, which is a couple of pages down, 35A. So keep going till you get to 35 capital A. Yep, that's it. So again, just a statement of priority order for the management of ground and surface water in the tank catchment, core allocation for health and well-being of water body itself, tangata whenua allocation, etc. So those are just a few examples that I wanted to draw to your attention of how Ms. Wilson's recommended approach reframes the paradigm and the statement of priorities, the hierarchy, if you will, in a way that, in her evidence, gives effect to the 2020 MPSFM. So I'll leave it at that, thank you. And Ms. Wilson obviously will be keen to receive questions on drafting, or I'm happy to take those as well as we go. The next heading was cultural expertise, and just to really reinforce a point that commissioners will be very familiar with, that it is for tangata whenua and mana whenua to state their tikanga, and only they can be the experts in their own tikanga. And so we can't take it from consultants, we have to hear it from the people themselves, and you've received that evidence, so you're very clear around where the tangata whenua submitters, their position is in relation to their protection of their ancestral waters. I've just about covered the key points I wanted to cover, but just on the topic of drafting, and this is my paragraph 33, perhaps I was a little unkind but in my first sentence, but because there is some verbiage here that, it is frankly unreasonable to have, for one plan change, one catchment, we've got 18 objectives and around 60 policies. And Ms. Wilson reminds me that she's drafted district plans, and she's drafted district plans which have less in toto. So, the problem with having so many objectives, so many policies, is it becomes a shopping list. There's no clear sense of priorities. That does not reflect the MPSFM, and it's going to create uncertainty in the developer environment, commercial users, tangata whenua, etc. So we really need to take the red pen and cut some of this down in my submission. And so we say that, well, let's take the time now to get it right. If commissioners make that call that, well, yes, Plan Change 9, there is some merit in having a plan change for this catchment, but we think it needs a substantial redraft, again, to reflect the MPSFM. It's within your powers to direct that takes place, and you can give interim directions to require that process to happen now, rather than leaving it to the Environment Court to sort of resolve later. So we say that's a good use of your powers. It is perhaps unfortunate, my para 38, that to a large extent it feels as if the iwi authority, and I'm sure other tangata whenua submitters feel similarly, have been left to one side, and there's not a lot of interchange in the addendum report by the officers in relation to what were offered as constructive changes to the Plan Change 9 wording. So there hasn't really been that constructive response in our submission. I've dealt with the procedural matters, and we're grateful to the Chair for your indications on those. So just sort of concluding comments, I do just make a point, and Peter Fraser is here today to speak to his evidence, but it is again a bit of a concern that there was simply no reference at all to his economics evidence, which was offered up in an attempt to assist commissioners. There is a concern that there was a sort of death by 180-page PowerPoint put up by Mr. Cole, and it doesn't really go anywhere, but it is relied on by the Section 42A report as evidence of, absence of adverse social effects from having from the plan changes drafted. So hence the iwi authority thought you would benefit from having some independent economic expert evidence on that, and so Mr. Fraser will speak to his evidence because we think that's important. So in terms of our concluding comments, there is what I've called a grand failure with Plan Change 9. It doesn't identify a clear statement of priorities that reflects the higher order instruments, including the MPSFM, and it is the opportunity here for commissioners to correct that through the use of your powers to direct, a redrafting essentially. A number of the harder questions seem to have been deferred, such as imposing stronger allocation and abstraction limits. Some of those have been deferred pending monitoring and collection of data. But the problem with that approach is that it's not reflective of a more precautionary approach. We know that there are significant adverse effects happening now. More needs to happen than simply the process for collection of data. And we've described it as an urgent need for remedial action to address the statutory imperatives. Tangata whenua evidence is that treasured rivers and streams are dry, groundwater and springs are at risk, cultural practices are prevented or imperilled. Urgency requires a precautionary approach to avoid ongoing significant adverse biophysical and cultural impacts. Actual and reasonable use has resulted in over-allocation and over-abstraction. Boldness and a corrective approach are needed within a relatively short time frame to achieve sustainable management and the directive priorities required by the MPSFM. That word boldness comes out of Shade's evidence, and it's an appropriate use of that term in my submission. And we've then outlined, and you've heard it already from me, that the two pathways forward in our submission, radical change, substantial change to the Plan Change 9, or decline. And if we decline, the question might arise, well, what happens if there is no Plan Change 9? Well, we think that there are sufficient protections in place on a transitional basis up to 2024, by which time Council must have notified a region-wide response to the MPSFM 2020. I've given you a very short, perhaps superficial summary of some of the key points in the attachment to that submission. And so water scarcity for mahinga kai, cultural practices and the very survival of hapu and marae reflects poor planning choices by the Regional Council and a failure to make hard choices so that nature can be given first priority, nature and the well-being of water. Because of water scarcity, tangata whenua are being asked to compromise their values and their relationships with water, for example by mixing waters at Paritua in breach of tikanga because it is better to have some water than nothing. and the proposal for a cultural share taken from high flow storage. The flow of the paritua must be restored. We say this type of VEX compromise would not be required if Plan Change 9 implemented the hierarchy of values in the MPSFM and relevant treaty principles, including exercise of rangatiratanga and the active protection of taonga. Thank you. Those are the legal submissions. Kia ora.
I might just see if we've got any particular questions. We were sort of asking, well, I was certainly asking as we were going, but I'll just see if any other panel have got questions.
I'm interested in your repeated use, I guess, of bold environmental bottom line, and how far you see that boldness really stretching. One of the things that springs to my mind is the one around language use, and in the vernacular, I suppose, is one way of describing it. It's around the way in which the RMA deals with words and stuff like that. It's not always easy for iwi or Māori to understand or to follow what's being said. But at the same time, you've heard the last couple of days here, Māori use their language, and that's always not that easy to follow either from others. And I always have a fear that we'll continue to talk past each other. So hence I warm to your repeated reference to bold and environmental bottom lines. But do you see that going beyond just the legal constraints in which I think you were trying to describe it?
So, interestingly, and it's a great question, when we first had our first team meeting around how we would approach presenting evidence to you in legal submissions, we decided we might start with the rules, looking at the rules, because normally one goes, top-down objectives, policies, and then, of course, rules implement. But as you know, the devil's in the details. So whatever is in the rules is where your bottom lines are ultimately going to be expressed, and whether they're bold or status quo related. And so I think Ms. Wilson will be able to speak to, answer your question in a drafting sense around how we've approached the rules. But otherwise, I certainly accept your point, well made, that there is a risk of talking past each other, different paradigms, but what makes this perhaps a simpler exercise for commissioners is you've got a clear statement of the hierarchy in the MPSFM, so you know which way you have to go in my submission.
Yeah, I think that's the only observation I want to make. I mean, I agree with the chair that you've sort of touched on and answered pretty much most of the fundamental questions I had, but I think, having to come up with something new, and the very question you asked, if you did it again, how would you, that is that kind of sentiment that I think that keeps buzzing around in my head. For example, your two pathways are either bold or nothing.
Yes.
And that would be a pity if people weren't bold enough, which might then lead to this, if we're not going to be that bold, we just don't do it. And then we got to wait for the next cycle of, the 2024.
Yes, and we wanted to obviously be constructive to assist you by having that redraft, there for you to understand where we were coming from.
Yeah, thank you.
Dr. Cowie?
Just in relation to your comment that it was, these aren't your words, that it was a no-brainer that we would include Te Mana Te Whai. Can I put a different view to you, which is that if it's implemented in just a part of the region, then you have a potentially inconsistent management framework. So it wouldn't apply to the Wairau catchment, the Mohaka catchment, the East catchment, Tukituki, Waipawa, etc., but rather to a subset of the region. The way I read the national policy statement is that the council must amend its regional plan and regional policy statement for the whole region to incorporate that. Can you comment on that alternative view?
Sure. And to do so, I might ask that we get the NPS7 back up on the screen, please, at clause 4.1. And just while that's happening, the answer is in two parts. The first part is that, just to remind you, clause 4.1 says that every local authority must give effect to the NPS, quote, as soon as reasonably practicable, 4.1. So there's no time like the present, and you have a duty to do it now, not later. The second point is that it is the regional council that made the judgment call to focus in on the tank catchments. And if that means there's a more stringent regime for those catchments than others, that's the judgment call that's been made. That's the scope, as you know, of your powers. And so, again, it must be appropriate to have a more compliant regime for the catchment than elsewhere in the region. And the final point is the approach anyway taken in the NPS-FM allows you to chunk it down. I mean, you can have an FMU that is region-wide, or you can have it, as you know, on a more specific, even water body basis. And of course, the direction of travel is in favour of giving effect to the NPS. So all of those reasons suggest we need to get on with the job with respect in terms of the tank catchment. And just on that, it is interesting if we go to 3.3 of, again, the NPS. 3.3, so 2, 3, yeah, way down. So, what I thought was interesting, if you look at the long-term vision clause in 3.3, bracket 2, bracket A, long-term visions may be set at FMU, part of FMU or catchment level. So you're not precluded from adopting a catchment-based approach. And so there's no fetter or prevention of you focusing in on the tank catchment now and dealing with the balance of the region. By 2024, of course, you'll need to revisit Plan Change 9 in that region-wide exercise, unfortunately. Anyway, so I think that's an answer.
I just had a supplementary question to that, and that was just around the temporal application of the NPS-FM 2020, and you've touched on it. Do you see a difference of giving effect to the National Policy Statement 2020 in policy terms, like plan changes, and outcomes in terms of deliverables on the ground? And I'm thinking particularly of the Waikato example, Plan Change 1, where they have they've proposed a time frame which is beyond the lifetimes of probably 2 generations at least. And that's quite different to where they started when they were talking about 30 years. So I just wondered if you had a view.
If I correctly understood the question, it's really around what's our time frame to give effect in the context of Plan Change 9. And that's partly relies on what the evidence is, I suppose, around what are the significant adverse effects arising and how do we avoid those effects, not only mitigate but avoid them. And so that must be relevant to the time frame involved. And again, a bold time frame is what we're advocating and your evidence addresses. I think you'll find Shade can give you a bit, probably even better answer than me, just around that timing question when he gives his evidence, and he will make a note of that. Just to, I'll pass the ball to him on that.
I suppose so. This wasn't specifically a question for yourself, but it's going to come up later in.
I mean, I'm happy for him to answer now if that would assist you, so we deal with it.
We can wait till later. That's fine. So we can wait till later.
Oh, you wait. Oh, sorry, I missed it.
And just giving a heads up, just in terms of Ngai Tiuka's evidence, I've got a question around the weight that we should give to the statutory acknowledgements, specific to the deed of settlement and the legislation for the Settlement Act, and then how that applies to the RMA. But notwithstanding, and it's not a question about the values that are identified in the acknowledgements, it's about the weight that we should give. But we can pick it up at that time, perhaps.
Would you mind if I add a comment about Commissioner Cowie's question around the potential for if the tank plan, if PPC 9 gives effect to Te Mana Tiwai, but the other catchments don't, and that potential inconsistency? I'll just remind the commissioners that this NPS is different than previous NPSs and in fact other NPSs, in that we now have a blanket requirement to give effect to Te Mana Tiwai in a general sense, making any decisions, not just matters to which the NPS specifically requires. So I would expect at a implementation and a practitioner level that when any decisions are being made within the other catchments within the region, that they would be made with that in mind, and in fact having to give effect to Te Mana Tiwai in those decisions.
Thank you.
Thanks for the heads up. So we're in, is Nahiwi here now? Or? Okay, he's been detained, so I'll pass the baton to Niall. Thank you.
Kia ora. Tēnā koutou raurangatira mā, tēnā koutou nā haukainga, nā hapu, tēnā koutou te poari. Ko te whai atu motu te whare tīpuna, ko waikare moana te waikaukau o aku mātua tīpuna, ko tūhoi, ruapani, Ngati Kahunu, nā iwi, ko nai o Tiuka ahau. Just before I introduce myself or give a background, personal background, I'd just like to acknowledge all those who have participated in this process, tangata whenua. In that formal stakeholder process, there was almost 30 tangata whenua who formally came and left, participated, and no doubt hundreds of more who have contributed in these hearings and prior to inform management of this catchment and to inform myself and others in advocating on behalf of tangata whenua and on behalf of these waterways. And similar to, I guess, our council's evidence, feel free to interject with any questions to perhaps tailor my kōrero. I'm not going to read my entire 68 pages.
I'm glad of that.
Oh,
I'll
do my best to summarise, but it has been a long process, and I have been involved since the beginning, 6 or 7 years of tank, and a couple of years after, still in the thick of it, pretty much almost 10 years.
I think what we're going to do is we'll hear you, so you can make a summary, pick up the main points of your evidence, and then we'll ask questions afterwards.
Cool. So I'm the Director of Environment and Natural Resources for Ngati Kahunu. I've worked at the iwi for over 10 years, 2 or 3 years I think as the manager. Born and raised in Hastings, save for 5 years boarding school in Pukehou, and 10 years in Wellington, where I spent my time. I worked on the chain at Taylor Preston's meatworks. I studied science at Victoria University, and eventually spent 6 years working for Statistics New Zealand as a statistical analyst before returning back to Heretaunga, basically raise my family and enjoy the natural surrounds this whenua and these waters have to offer.
I quite frequently frequent these waterways with my children, and in fact there's a big picture of my son right in front of you. He's there crouching over the river, and my daughter is in the creek with me. They're facing me, not you, but they're scattered around in these pictures here.
Have a look at them yesterday.
I also get told off from revealing our secret airline spot on one of these waterways. And
where is it?
No, they'll tell me off because I've already showed too many people, and my daughter gets quite upset. To the extent relevant, I consider I'm an expert in tai au, or environmental values, principles, rights and interests, in supporting tangata whenua aspirations in terms of how they best and fairly provided for in tai au policy and legislation. And one of the commissioners that was mentioned before, and that's the knuckle, that's the crux of the issue. How does our culture fit within these this Western tenure system of management, and reflected in policy and legislation, including concepts of mauri, mana o te wai, practices of mahinga kai, kaitiakitanga, and manaakitanga. So again, it's articulating the effects on tangata whenua, values, rights, cultural relationships, that and our taonga. This is my difficult field of expertise. I participated, like I said, in the tank process from its inception. I save a few meetings where I was asked if I was actually asked initially not to participate. There were too many tangata whenua reps there, and then I was asked to come back right at the early start. I've actually been involved in every plan change, from plan change 4, 5, 6, 7, 8, 9, aside from plan change 4, which is the built environment plan. I've been quite significantly involved on tangata whenua in every single other plan change, which I can elaborate on further if need be. So, just background from Ngati Kahunu Iwi Authority. It's the third largest iwi, Ngati Kahunu's third largest iwi, with approximately 62,000 from the 2013 census. We will have almost 40,000 registered members, and the rohe is quite significant from Paritu, north of Wairoa, to Tuakirai in South Wairarapa, so the second largest tribal rohe in the country geographically. The mission statement of Ngati Kahunu is to enhance the mana and well-being of the iwi. So that's front and centre in the work that I do. Our structure includes 6 tai whenua that represents the 6 takiwa within the wider Ngati Kahunu rohe. For these catchments, the tai whenua o te whanganui o Rotu and the tai whenua o Heretaunga are relevant. So we maintain an independent position to advocate on behalf of Ngā Uri o Ngāti Kahunu, and we work closely with our tai whenua and hapu to provide advice and support. We also work with the relevant PSGEs, and this was evident or the case with this plan change after it went from the tank stakeholder group. We are provided advice and worked with the RPC tangata whenua members, or the Regional Planning Committee tangata whenua members, and basically remained in the thick of it, and was provided significant advice. So the position on Ngati Kahunu, which I think Gray will go into further, and our council, Rob Enright, has outlined, we want to address the substantive causes of over-abstraction, not just the symptoms, but the underlying causes of declining and degrading water quality, ground and surface water levels, and past mismanagement of the waters in Heretaunga and Ahuriri. So there's been a heavy reliance is placed on experimental mitigation measures designed to maintain, in my opinion, irrigation or development with scant regard or secondary regard of how they contribute to further adverse effects on tangata whenua values and culture and our relationships, the waterways, the natural character, and natural processes and ecological values. In my opinion, tangata whenua values are considered last unless those values correspond with predominantly the economical Western values. It's it's always this balanced battle. And as a result, tangata whenua are constantly frustrated, and you would have heard from the evidence or felt the frustration over the last couple of days, because we're always looking for remedies, enhancement and restoration of the natural environment, relationship with it. And a lot of our people, some of these pictures on the wall show monitoring, assessing the environment, and there's big emphasis on planting trees or doing whatever we can, really, in the space of frustration. And we've got this opportunity with this catchment plan to, it's been mentioned, to take a bold step and move away from just being involved in planting trees and monitoring the decline. PC9 emits policy that regulates to avoid adverse effects in favour of mitigation measures. Mitigation measures has often been the first offer to tangata whenua, will mitigate adverse effects, because it's often in a difficult space, and we leave towards the end. Avoid effects on tangata whenua is a rarity. Maintaining security of supply over and above security of supply to waterways is omitted in an issue, because cultural values, ecological values, even domestic drinking water needs, which I'll touch on later, become secondary. So te mana o te wai and wai Māori are effectively second to te mana of other interests, let's put it that way. And this approach isn't sustainable. I think what is offered as a hierarchy is a tilt in the direction of sustainable management, and evidence from Maury Black talks about the kind of paradigm shift, or that turmoil between development and management. So minimal regulation and enablement of activities to increase water use, for example, through flow augmentation, which I'll touch on later. So just talking about the monitoring and the planting of trees, and I call it a new age application of kaitiakitanga, where kaitiakitanga was that relationship of the waterways, where the waterways sustained us physically or metaphysically with kai awa or mahinga kai, which now, if it doesn't provide that practice or that relationship, we're being kaitiaki to monitor, to try and do anything, but we've lost that kai actually component. And we heard evidence yesterday where mahinga kai, such as tuna watercress, was collected year round and used as a food source. But perhaps the connection is not well made, that that's a form of cultural commerce, where that's our holistically intertwined with our social, cultural, environment, all these spheres that are disconnected in the management regime, but in our practices, that the awa is the pātaka or the kai cupboard, or was awa, and in the 10 catchments, the whānga nui a rotu. So in one issue with that is that tangata whenua are often seen as environmentalists or greenies, and in the stakeholder process we are inadvertently at times pigeonholed in that space, where it's somewhat seen to the left of the perhaps what you might call mainstream thinking. But of course, for tangata whenua, our regard to the environment and what it provides us is centric to our worldview, and it's my opinion that provisions in legislation and statute provide that centric worldview should be considered more centric in policy design than it's not. So, So we seek directive regulation that establishes hard limits in terms of water quality and water quantity, water takes, water flows and levels. we've done a significant amount of talking and sharing our values, our principles. I'm not just speaking for South Ngati Kahunu. We've incorporated these significant avenues where those have been shared, and they're captured in the regional resource management plan and the schedules or in the Māori dimension part, but they're not well fleshed out in subsequent policy. So I'd just like to touch on the key issues, and I've highlighted two key main issues, which I think all other issues stem from. If we address these two key main ones, with at least in this catchment, then hopefully there'll be a flow-on effect, excuse the pun, for other issues. So the one I've spoken about at length in my submission, and I don't think is mentioned by any other submitters possibly, or any other evidence, is the non-regulatory approach to PPC 9 and the origins of that non-regulatory approach. So the fundamental issue for tangata whenua in terms of natural resource management and the approach is that it adopts our approach or a flavour promoted in the regional policy statement in the Hawke's Bay Regional Resource Management Plan. And I use the word flavour because that's the language used, and not in any documents per se, but in the discussions for the direction of the management approach from regional council. So this approach being one of minimal regulation, enablement of activities, working with resource users, and education rather than regulation. So it's almost an ideology or with ambiguous origin in whakapapa. So where did it come from, and why does it underpin resource management in Hawke's Bay? This is the big knuckle crux of the underlying issues, and this flavour is peppered all the way through subsequent policy documents, including PC9. There's, in my opinion, there's no formal requirement for PC9 to the aforementioned flavour or approach. And I have worked in Ngati Kahunu for 10 years, and in this time, the appropriateness of this value of this approach has never been discussed or consulted on. And this approach has had adverse impacts on tangata whenua practice and desired environmental incomes, and ultimately relationship with our environment. PC9, as it stands, runs the risk of perpetuating problems for future generations to fix. I've respectfully asked to just talk about this fundamental issue numerous times, and it seems to be not within scope of any discussions or not entertained, and that's unfortunate, as it doesn't align with past and current national policy statements. But in my opinion, rather than direct conflict with the trajectory, in particular te mano te wai and the associated hierarchy, if it's in direct contrary, that clause about giving effect to te mano te wai as soon as practicable, I think definitely fits, because that opposite trajectory, that 180, is no longer fit for purpose. I understand the Kotahi plan aims to address almost everything. I think it should be the E Rua plan, and there should be a couple of phases to realign the higher order region-wide documents to the national policy statement. Notwithstanding, we're here in the PC9 to make decisions, but that's my view on the wider application. And I also, in my opinion, think this approach has caused increasing number of judicial criticisms with other rulings, some of which I highlighted. So just briefly, the Tukituki Catchment proposal. So that was basically a minimal regulation approach taken there to manage a single nutrients, phosphorus, and to leave nitrogen to its own devices. The Board of Inquiry in criticism said that that was a relatively, and I quote, a relatively hands-off approach to the management of nitrogen. So that approach, single nutrient approach, was rejected, and stronger limits were endorsed, stronger limits and targets than what was originally proposed. So it's been an ongoing theme, and of course we propose hard environmental and cultural limits. The other case where this background or approach is applicable is the Ngati Kahunu Universe Hawke's Bay Regional Council. In 2004, I presented the iwi's legal appeal on Plan Change 5 to the Environment Court. Mare Apatu, Maori Black and Ngahiwi Tamona each provided quite emphatic and influential evidence to that court process, and our appeal was successful, and in it we set national case law in interpreting water quality policy for the National Policy Statement of Freshwater Management 2014. So the no overs and unders approach coined by MFE, or base of no averaging, basically what it is, or because if you average out your data for water quality, it can be a bit sneaky, and we miss. That's a highly technical term. It could be quite sneaky. We miss actually potentially addressing the issue. So there was criticism there from the court that the rationale to basic overs and unders and overall water quality and average it, that approach was seen by the court as fundamentally flawed and illogical. We retained the object, 6 of them was retaining the objective 21 that was spoken of, no degradation to the existing groundwater quality in the Hiratonga Plains and Ruataniwha Plains system. While that was success on paper, I'm sure you understand, I think it was a year later, the largest gastro outbreak in this country's recorded history occurred basically on the same water body that we went to court on to protect. So while we have these mechanisms on paper, it's not lost on us that may not result in the outcome. And in Objective 22, we also had the reference to productive aquifer in that regional policy statement removed. The court sided with us on my argument that this was looking at the potential use of the water body and not giving its respect with terms of its own mana, that it might be of high quality. So it was, I guess that could fall through the gap in other water bodies not being protected. However, this PC9 doesn't give effect to the RPS objective of no degradation of groundwater quality in the Hiratonga Plains aquifer systems, and I'll touch on that a bit later. So just to support, I mean, don't take my words for it that this approach permeates through PC9. There was a peer review conducted in 2018 by Peter Constantine. This was towards the end of the tank stakeholder process. It wasn't actually discussed at any great length in the stakeholder process, and I think we could have benefited from seeing outside independent peer review. That was commissioned by Regional Council, and I've attached as exhibits, and apologies for the amount of exhibits. I don't expect you to read them all, but
We have. I
should have said,
for it.
yes, apologies about that. But I think that the peer review comments are quite useful, and I guess I turn to those because for support, to demonstrate that our issues are not, unique or rare. And as was highlighted in the peer review was the non-regulatory flavour. And in fact, the points I made about the approach was what has been taken was a direct quote from the peer reviewer himself. And in particular, the peer reviewer said, the success of the plan change requires a paradigm shift, which we identify with, in terms of how land uses are undertaken, and such a shift would normally be supported by directive regulation. This is not the case here, and that's the quote from the peer reviewer. However, RMP is focused less on regulation and more on enablement of activities coupled with education, voluntary compliance, and council-funded and managed programs. And just a couple other relevant comments from the peer reviewer. The plan change is very permissive, and I'm left wondering of how this is going to sit within the NPS FM 2014 and amended 2017. Of course, the 2020 wasn't out by the time of these comments. Other noting comments from the peer reviewer. Further to this, I'm not certain that objectives of the plan change are clearly enough articulated. I suspect that this flows from a desire to minimise regulation in the RRMP. I found many of the policies to be focused on process rather than outcome. Many of the policies are very lengthy and could be greatly improved if they split up and more focused, and I don't see any mention of FMUs in the plan change. Is this deliberate or an omission? So those were all comments from the peer reviewer where we basically have similar thoughts and concerns. I don't think the peer reviewer is Ngati Kahunu, but we're very similar. The Department of Conservation submission shares some of these concerns and some of our concerns, and notably they're not present here today. We're in dialogue with them. Basically the time frame was and budgeting issues precluded them from being there, and I spoke to the manager of that team and he said it was okay to say that. I do not think that, given the light of this peer review and our comments, that these issues can be fixed by a few minor tweaks or more tangata whenua consultation. Just on consultation, I think, yes, you don't want to get rid of all the engagement that's been had, but the important part is the content of that engagement, whether it, and precluding tank as well, and in our iwi and hapu management plans, the content part, not just meeting. So tank, in my view, carries on this approach of non-regulatory approach, although it wasn't outright discussed in full transparency while going through the tank process. The outcome of the draft plan obviously aligns with the regional policy statement in terms of the approach, even though it's not actual specific policy to have this approach. There's coincidentally, well, I say coincidentally because we weren't discussed that, do you prefer this non-regulatory approach? So, for example, tangata whenua obviously want the streams returned in the paritua, and a directive approach would to reduce water takes. It's over-allocated, and the requirement of the current MPS and previous MPS is to phase out over-allocation. This would be through the standard method of reducing water takes, and that was a reluctant position to be inserted within the policy. There should be no need for Policy 44, which doesn't give any certainty to the stream and to tangata whenua and their relationship. It's kind of feel-good policy. We repeatedly asked to insert reduction in water takes, and we met quite a bit of resistance. It was in the plan, out of the plan, in the plan, out of the plan, and sort of went around in circles, and Mr. Maury Black touched on it in his evidence. So in essence, resource management views, tangata whenua resource management views gain greater traction if they align with the following: minimal regulation, enablement of activities coupled with education, voluntary compliance, council-funded management regimes. We seek a plan that has established hard limits in terms of water quality, water takes, water flows and levels. We shouldn't expect to hold people's hands all the way through the process to meet those targets and hard limits and have confidence in our statutory managers. Fundamentally, PC9 as proposed creates an unstable and uncertain foundation going forward and provides little confidence that the adverse impacts on tangata whenua in terms of resource management over the last 2 or 3 decades will be addressed, and that further decline of available values will be halted. As our council pointed out, the current framework for the management of their waterways is, in our opinion, better than the one proposed The one proposed removes Objective 21, no degradation of the aquifer, and it also removes a significant amount of other policies, Objective 41, 42 to 44, around the water quantity of groundwater. And one of those policies, 77, talking about we should avoid adverse impacts on the abstraction. Sorry, I can't remember the words off my head, but off the top of my head, but it's around the avoiding adverse impacts of over abstraction. So the other big issue, essentially the contentious issue, is disappearing water. I'll call it the draining of our tank. It's the biggest environment and cultural issue in Heretaunga, the disappearance of fresh water. The Section 42A, Appendix 11, I felt summed it up well. I think it was page 2 or 1. And I quote, groundwater levels and river and stream flows are decreasing due to water use. The condition of freshwater resources in the Heretaunga Plains is degrading, and entails that this circumstance is not sustainable. So tangata whenua, our own mātauranga have observed this declining and degrading trend for years, and have made submissions numerous times, and as you heard yesterday, they felt ignored. In November 2014, a hui hapu held at Waipatu unanimously decided to call for a moratorium on all new consents or increases to consents for water extraction from the Heretaunga aquifer, and I attached as exhibit our media release to that effect. In contrast, almost 3 years later, in August 2017, Regional Council media release stated, new scientific advice from the Hawke's Bay Regional Council indicates the effects of current groundwater takes in the Heretaunga aquifer are at the limit of what is environmentally acceptable. Well, in fact, prior to that 2017 media release, and during the tank meetings, I think it was a year and a half prior to that 2017 media release, we actually had a presentation from Regional Council hydrologist Pavel Rakowski, and a PowerPoint presentation. We received a lot of PowerPoint presentation. It was death by PowerPoint almost over 8 years of science, but in that there was one point which the word, it said dangerous. If we continue on this current trajectory of allocation, and there's an image down here with the use I'll talk about later, and there's a black line. Yes, that one over there. That black line is the full allocation. So if every water user used their full allocation, which is that black line, he said it'll be dangerous. And when I questioned what does that mean, he said risks like saltwater intrusion, which was quite alarming there and startling. And so my point being is, that didn't come through, that this is over-allocated formally until years later. Even the 2017 media release does not mention over-allocation. And I just correct the rebuttal evidence from Kerry Edmonds, who said that there was a over-allocation media release. It doesn't say over-allocation at all. It's just getting used to it, while tangata whenua observations were, I think, we're seeing that it was over-allocated in 2014. And I also like to point to a paper, perhaps my first slide. Yep.
I'm just wondering, Mr. Chuka, we were looking for a summary and catch all your main points, and you're covering the comprehensive submission which we've read, and I'm just wondering, just for the purposes of time, if there were some points that you wanted to make, because I want to give time to questions, because we have a few questions of you while we've got you here.
Yeah, okay. Good. It's been a long process, but this paper I'm referring to is a new exhibit, and I'm highlighting that in 1989, this paper, maybe to there, mentions the risks of that there's intensive horticulture, irrigation, that the scheme as a solution was to prevent mining and basically over allocation at that point. And there was a slide provided by Mr. Maury Black that also, I think it was the same year or a couple of years later, that talked about over allocation way back then. So almost 20 years before it was accepted. And the problem with that, if we don't identify the causes, it makes it that much harder to identify, to treat the problem and implement a solution. The Paritua is a significant example. The PC9 doesn't propose any low flow targets or limits, nor monitoring around these marae and this hapu at all. That's within our submission to provide that policy. Also, I'll speak about the water storage, or perhaps I'll touch on it now. That policy or those discussions opposed retaining environmental flow for these streams, contrary to some of the media statements from Regional Council leadership. That's not part of the policy, and it wasn't part of the discussions, and I was in the subgroup to try and push for that, and it was put on back onto me to write the policy for environmental residual flow is what it was discussed, to come from that water storage to offset. The comment received from the industry group, we want a leader in, we want a leader out. Mr. Enright has talked about our treaty issues. I would apply that at least active protection in the principles. And the duty of the Crown is not merely to passive but extensive active protection of Māori and the use of our lands, waters in the fullest extent practicable. Of course, Ngati Kahunu has a claim to the Waitangi Tribunal 2358, and a number of hapu are party to those claims to assert our property rights and interests with respect to water, and the position is that we have never relinquished our rights and interests to water. And that ownership, as the Waitangi Tribunal explains, is perhaps not as a Western term might have it, but is originating from the ancestral relationship, the ongoing cultural and spiritual relationship of the waterway, and the use of resources associated. This matter is not recognised in PC9, and instead a high flow allocation has been offered, which reapproaches our right to our waterways as a commercial interest. I'll just go through. There's a number of Waitangi Tribunal claims that are relevant here. Besides 2358, there's the Y55 claim to Whanganui Aorotu, and that's there's the Ngati River claim in Kaweka Park, Y382, Y402 Park Ngati River claim, Y536 Pakowhai Native Reserve in Ngati River claim, and Y595. These are largely underpin the local treaty settlements. However, there's a significant number of issues raised on those claims that provides context and could be useful, I guess, and avoid the burden of further engagement if those matters were taken on board, and I've listed them there, the issues that were raised in those claims, like significant modification, pollution, degradation, etc. Statutory acknowledgements. So they've largely been underutilised, in my opinion, and they speak to...
I'm sorry, Mr. Tukituki, I just noticed we're up to page 19, sort of interpolating your evidence, and I just wanted, just in terms of time, because we have read your submission.
Yep.
Would it be possible if you'd be able to just summarise your main points, because we've read it and your exhibits, except for one which I couldn't open, and we've appreciated the time and effort you've put into preparing the submission. We'd really like to ask you some questions, because there are some things we'd like some clarification on. So with your leave, if you could make some main points perhaps, and that would allow us to ask you some questions, because we want to give time to that, because there are things that we don't quite understand.
Oh, okay. Well, I think I'll go through the parts that perhaps I'm assuming are the most difficult to understand, which is around over-allocation, abstraction, and flow augmentation.
Well, but perhaps we could do it a slightly different way. We could ask you some of those questions, and if there is anything else that
Sure.
you wanted to also raise, you could do that.
Yeah,
Would that be okay?
That's what I suggested at the front too.
Perhaps I'll start. The first one, and this is to yourself and maybe other members of your team, and it's the 70 million cubic metres limit that's being requested. I'm just wanting more understanding about where that number's come from. You'll appreciate there are a number of numbers in lots of the reports, but that particular number from your perspective,
Yep.
and how that meets your concerns, that would be helpful.
Well, I'll again refer to the Section 42A Appendix 11 report.
Yep.
Basically, we're going to manage the ins and the outs. If I just may stand up, because I don't know where it's on my slide, but it's in the picture in front of us.
We've got a break here. Maybe we'll just...
I saved it because there's a picture down there. So, this one here, groundwork budget. And my evidence was
Yep, I've got that one.
Say that this should be the highest consideration in terms of setting the allocation, the groundwater budget, and I think that was touched on.
So what's the source of that? What's the source of that?
Of this, the Hiratonga Aquifer Groundwater Model Development Report or Scenarios Report? Oh, gosh.
Dating from when,
It's in the summary report of the groundwater development model. So,
sorry, is that one of those August 2018 ones?
yes,
Thank you.
yes. So it's touched on in the Section 42A that we have to measure the in and outs. And this is the best available information, so I don't know why it was omitted from there, but basically you'll see this much water goes in and this much goes out, so it balances. What we're asking about, the 70 million limit, is around the groundwater pumping, which says it was 78.1. If you have a limit over that, then you're taking more water than what's going in. So there's been an amendment to that, I think, in the rebuttal evidence on that number that was actually used, or perhaps.
I understand your rationale. I'm just wondering where you derive the 70 as opposed to 71 or 72 or 73 or 74.
Well, it is a... I mean, Shade Smith will talk about this a bit more, but if we're going to address the adverse effects of over-abstraction, then it wouldn't be enough just to stop at that level, that balance. There is the slide that was in Appendix 11 with that downward trend on that graph. How do you stop that? If you stop at actual use, as been talked about, won't actually stop the decline. So if you could see that black line, which is similar to the picture, well, it's the same as the image here, shows that's the over allocated amount. And basically that's the theory. Even if we get rid of over allocation, it might not have any material effect on the amount of water being taken. You have to get to the over abstraction part, which means it's lower than what has been proposed. The proposed limit was initially 90 based on what demand for water, as Maury Black said, not what's been used. And it's been problematic in having the discussions because the mix between over-allocation, over-abstraction, and what it will do and what it won't do.
I guess my difficulty with that number is it's based on some pretty, it's a guesstimate rather than an accurate estimate from what I recollect of the groundwater report, and is potentially subject to some quite large errors, as are all the outflow numbers, and particularly the sea discharge, which has got no observations, and the groundwater pumping, which has got some data and estimated from demand modelling. So,
I'll just say, I mean, best available information of what we have to work with, and perhaps I'll pass it over to
If I could
planner.
just add to that, please. The number that's being promulgated as an appropriate allocation limit at 90 is, in my opinion, no more accurate, essentially, than what is being suggested by the iwi authority. It's based on best guesstimates of what is actually being extracted at the moment. And in fact, we've seen through the addendum report that there's been an update to those numbers. In fact, the 42A in a number of places, and I address this in my evidence, is predicated on the basis that council does not have enough information to implement an accurate allocation regime. Now, again, in terms of the changes that I've suggested, I have addressed a pathway through that. But where Mr. Tauka's coming from is that the 70 million is based, yes, it is a guesstimate, but it is based on a conservative one and implementing a precautionary approach based on the significant adverse and cultural effects that we are seeing now at the existing extraction rates that are occurring. And so the view of the iwi authority is that we must use a number that is lower than that rather than one that is in fact higher.
sure, I well understand that, or I think we well understand that. And that was based, I think, on the 2012-13, which was a drought year in terms of demand. So, yeah, thank you.
Thank you. That was helpful. Just in terms of our timing, we're going to stop for a break, and we'll look to come back we have a short break, 5 minutes past 11. Thank you.